Hello, I'm Rashi Goel and I'm legal intern at LEXIS and Company. In this video, I'll be talking about the reason why sedition and free speech cannot go together. So, the first reason is freedom of press and sedition cannot be balanced. Freedom of press is a fundamental right which is guaranteed under Article 19, Clause 1, Subclause A of the Indian Constitution. The state is empowered to restrict free speech under Article 19, Clause 2 on the ground that is threat to public order, decency, morality, and the security of the state. Indian jurisprudence makes it clear that citizens' right to free expression and state's power to restrict it cannot be seen on the equal footing. Free expression is a rule and restriction on it is an exception. The exception cannot be either equal to or more than the rule. Such restriction should pass the test of reasonableness as pronounced in the several judgments over the decades.
Second is mere criticism cannot be sedition. Explanation to Section 124A of IPC clearly defines the limit of law of sedition. It says that comments expressing disapprobation or disapproval of the measures of the government to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute the offense under this section. Comments expressing disapprobation or disapproval of the administrative or the other actions of the government also without exciting or attempting to excite hatred, disaffection do not constitute the offense under this act.
The Supreme Court, in its judgment of Kedarnath Singh vs. State of Bihar, further restricts the scope of sedition law. In this case, the court had read down Section 124A of the Indian Penal Code and held that the application of the provision should be limited to the acts involving intention or tendency to create disorder or disturbance of law and order or the incitement to the violence. Thus, Kedarnath Singh verdict makes the tendency test imperative for imposing sedition cases on anyone. Third reason is logic no longer exists. The Allahabad High Court in 1956 dismissed Section 124A of IPC as ultra-vires to the Indian Constitution. Unfortunately, the nation lost a golden opportunity to do away with the colonial relic with the Supreme Court refusing to strike down the section in 1962, though it was significantly restricted the scope of its use. As early 2016, the Supreme Court reiterated that the Kedarnath Singh verdict should be guiding principle in the application of sedition law. However, the court has its own logic in doing so. The said verdict says that it is well settled that if certain provisions of law construed in one way that would make them consistent with the Constitution and another interpretation would render them unconstitutional. The court would rule in favor of the former construction, but India's tryst with the sedition law reveals its extensive unconstitutional use, making it repeal necessary. Fourth is dishonor to India. Despite all its limitation, India is a vibrant democracy with a robust media tradition. As our former Prime Minister Nehru said, free press with all its limitation is always better than the controlled press. In countries like United States, Canada, Australia, United Kingdom, etc., the sedition law is practically in disuse. On the other hand, sedition law is operational in countries like Saudi Arabia, Turkey, Iran, Uzbekistan, etc. Surely, every Indian does not aspire to be in the dubious company of the later set of countries. Fifth is vagueness makes it invalid. Section 124A of IPC vaguely worded when it says whoever by words either spoken or written or by sign or by visual representation or otherwise brings or attempts to bring into hatred or contempt or excites to or try to excite or attempt to excite disaffection towards the government which is established by law in India shall be punished with the imprisonment of life. The expression disaffection includes disloyalty and feeling of enmity as per the Supreme Court verdict in Shreya Singhal vs. Union of India 2015. The vagueness of law can be sufficient ground for its invalidation. Sixth and last is sedition not part of Article 19 Clause 2. Indian Constitution says that fundamental right to free expression can only be subjected to reasonable restriction which are specified under Article 19 Clause 2, in which sedition is not included. The Constituent Assembly itself unanimously resolved not to include sedition as a ground to restrict free speech. Sedition was initially incorporated under Article 13 of the draft of Constitution, which is equivalent to the Article 19. Thank you.